Good morning, this is your Kelso Report for Thursday, October 25th. I'm your host, Clark Kelso. Our first case today involves the continuing struggle between casinos and advantage gamblers who count cards to beat the odds. Then we turn to the First Amendment rights of a university student newspaper. Our third case involves the measure of damages for injured pets. And we close with a trademark law decision involving the Winchester Mystery House. Well, in Vegas, the odds usually favor the house. And when a professional gambler uses techniques such as card counting in casino games such as blackjack, in order to change the odds to favor the gambler, the casinos have responded by telling those gamblers that they are no longer welcome to gamble at the casino, and that they will be cited for misdemeanor trespassing if they return. This warning is known in the trade as being trespassed. Some professional gamblers try to beat the system by coming back while wearing a disguise or using false IDs. In order to avoid burdening the municipal police with this somewhat silly casino workload, the casinos employ private security guards who, under state law that does require special training for those guards are permitted to issue misdemeanor citations. In Sal versus Desert Palace, a professional gambler who had been previously trespassed some 5 times came back to Caesar's Palace after having received a promotional invitation in the mail. When recognized by security and asked to leave, the plaintiff refused to present any identification and was taken into custody and escorted to a room for questioning while waiting for the city police to arrive. The plaintiff sued the casino and the municipal police officer who arrived for constitutional violations under the General Federal Civil Rights Statute, 42 U.S.C. Section 1983. The district court dismissed the claims, concluding that there was probable cause for the arrest both by the private security guard and the police officer. The Ninth Circuit affirmed on slightly different grounds. It agreed that the police officer had probable cause. With respect to the casino, it ruled that because the casino did not have any general policy or practice that violated the Constitution, the casino could not be held vicariously liable for the alleged tort committed by the private security guard. Since under the Supreme Court's decision in Monell versus Department of Social Services, a municipality can be held liable under Section 1983 only if the alleged constitutional violation is caused by a policy, practice, or custom of the municipality. In other words, there's no municipality vicarious liability under Section 1983. The key to the Ninth Circuit's conclusion was its holding that the Monell rule applied to the private security guards employed by the casino, since those guards were acting in lieu of municipal police officers in taking the plaintiff into custody for purposes of issuing the misdemeanor citation. Next, we have a free speech case. Freedom of thought and speech on university campuses is a tradition that stretches back literally hundreds of years, and it is a tradition that is constitutionally protected by our First Amendment. Efforts to restrict speech on university campuses, particularly, of course, efforts that are viewpoint-based or content-based, will generally be subject to strict or some form of heightened scrutiny. Such was the case in OSU Student Alliance versus Ray, where Oregon State University got a lesson in freedom of expression. According to the complaint, employees in Oregon State University's facilities department gathered up the outdoor news bins belonging to The Liberty, a conservative student monthly, and threw them in a heap by a dumpster in a storage yard. The employees acted pursuant to an unwritten and previously unenforced policy governing news bins on campus. They did not notify anyone at the Liberty before confiscating the news bins. And after the confiscation, university officials denied the paper permission to replace the bins anywhere but in 2 designated campus areas. limited areas to which the university's traditional student paper, the Daily Barometer, was not confined. The Liberty student editors and student publishers sued top officials of the university in federal court under Section 1983, and the Ninth Circuit had little difficulty finding constitutional violations. The university's own policies had declared that the university was open for free expression, so the court easily concluded the university was a public forum. Given that the supposed policy pursuant to which the bins were removed had never been announced or enforced previously, and that only the plaintiff's publications' bins had been confiscated, the court also easily concluded that the confiscation was likely to have been viewpoint or content-based, and was in any event done pursuant to an utterly standardless policy, and was therefore unconstitutional. The university will now have to revisit its policy regarding the placement of newspaper bins on campus. Next, we turn to a California state court decision involving remedies for injuries to pets. Now, it usually comes as a shock to law students that the law generally treats household pets as nothing more than personal property. So when your favorite dog or cat is severely injured, damages are usually limited by the market value of the property, which is usually a relatively modest amount. And the owner usually does not recover any damages for the owner's emotional distress. Pets are not people. They are property. Well, in recent years, a few courts around the country, encouraged by a band of zealous scholars, have started to recognize exceptions to the general rule. We first saw some different results in cases where the defendant deliberately injured a household pet, sometimes with a specific intention of causing the owner to suffer emotional distress. But in yesterday's decision in Martinez v. Robledo, the Second District went all the way, holding that a pet owner is generally not limited to the market value of the pet and may recover the reasonable and necessary costs incurred for the treatment and care of the pet attributable to the injury. The court reached this conclusion in resolving two consolidated appeals. In the first case, a neighbor had shot the plaintiff's dog, who was barking at the defendant's dog and very close to fighting with them. It required amputation of the dog's back leg and vet costs of some $20,000. In the second case, a vet simply committed malpractice during surgery, resulting in subsequent emergency visits and a second surgery, costing $38,000. In both cases, the market value of the animal was under $1,000. We are relying upon a First District decision in a similar case last year in Kimes v. Grosser. The Second District rejected the common law rule that would have limited damages by the pet's market value, and held that pets are a special type of property, where the measure of damages should include the cost to repair, even though that far exceeds the diminution in market value. As the Second District explained, quote, "We agree that the determination of a pet's value cannot be made solely by looking to the marketplace. If the rule were otherwise, an injured animal's owner would bear most or all of the costs for the medical care required to treat the injury caused by a tortfeasor, while the tortfeasor's liability for such costs would in most cases be minimal, no matter how horrific the wrongdoer's conduct or how gross the negligence of a veterinarian or other animal professional," close quote. Now, the Second District's decision is a substantial departure from the common law rule, and is arguably contrary to Section 491 of the Penal Code, which provides that dogs are personal property, and their value is to be ascertained in the same manner as the value of other property. It does seem to me the California Supreme Court should take this case up for review, since injuries to animals is such a common occurrence, and the difference in the measure of damages is so substantial. However the court resolves it is fine, but it's time to get some clarity in the law in this particular area. Finally, we have a case involving allegations of trademark infringement and unfair competition. The defendant released its film Haunting of Winchester House without securing the consent of the owner of the Winchester Mystery House for the use of the name. And the owner sued. Unfortunately for the plaintiff, it is a victim of its own success. According to the 6th District in Winchester Mystery House v. Global Asylum, the phrase Winchester Mystery House has taken on in the public's mind a meaning that is independent of its meaning as a mark that designates the popular attraction in San Jose. And because of this fact, the phrase may be used as a title of a work of art or entertainment without infringing the trademark, unless the title has no artistic relevance to the underlying work whatsoever, or, if it has some artistic relevance, unless the title explicitly misleads as to the source or the content of the work. So long as the title has artistic relevance and does not explicitly mislead, its use is protected by the First Amendment. And that provides a complete defense to trademark infringement and other similar claims. Well, factually, the title in this case did bear some artistic relevance to the movie, which was very loosely based on the life of Sarah Winchester. And the movie marketing materials made it clear that the movie had no connection to the real Winchester Mystery House. So instead of suing for damages, the owners of the Winchester Mystery House simply should be grateful for the artistic recognition and compliment. And that's it for today's Kelso Report. Have a great day in the law.